place. Instead of a renegade Serb militia whose action the court was unable to attribute to a state, in Myanmar it was the state itself through its armed forces which perpetrated these atrocities. Instead of an impromptu intent formed immediately prior to the genocidal acts, in Myanmar there was a plan prepared well in advance of the clearance operations at the highest level of the armed forces and dutifully executed by subordinate officers and enlisted personnel throughout northern Rakhine State, employing the very same modus operandi. In Myanmar, in contrast to Bosnia, genocide, including genocidal intent, is proven not only by particular circumstances in particular locations, but also by a pattern of conduct demonstrating the existence of a plan, the intent of which it can only reasonably be inferred from its nature and the manner of its execution was to destroy the Rohingya as a group. Mr. President, the evidence before you also distinguishes the present case from the Croatia case. In Croatia, the court found neither particular circumstances, nothing equivalent to the massacre at Srebrenica, for example, nor a pattern of conduct from which genocidal intent was the only reasonable inference to be drawn. The case is nevertheless helpful to us here for several reasons. First, the court found that the actions of the respondent state constituted a pattern of conduct, evidenced by what it called, quote, similarities in terms of the modus operandi used between some of the attacks confirmed to have taken place, end of quote. These similarities included attacking and occupying Croat localities and creating what the court called, quote, a climate of fear and coercion by committing a number of acts that constitute the actus reus of genocide within the meaning of Article 2A and B of the Convention. Finally, the occupation would end with the forced expulsion of the Croat population from these localities, end of quote. By this is a pattern of conduct by Myanmar across the expansive geographic area in which the majority of Rohingya lived in northern Rakhine State. As you have seen, this was the conclusion reached by the UN fact-finding mission. Second, to determine whether genocidal intent could be reasonably inferred from the respondent state's pattern of conduct, the court considered factors that largely overlap those employed by the UN fact-finding mission in our case, and which the mission concluded were indisputably present in our case. According to the court, the most important factors in revealing a genocidal intent were, as Professor Sands recalled earlier, 1, the scale and alleged systematic nature of the attacks. Check. 2, the attacks are said to have caused casualties and damage far in excess of what was justified by military necessity. Check. 3, the specific targeting of Croats, in this case, the targeting of Rohingya Muslims. Check. 4, the nature, extent, and degree of the injuries caused to the Croat population. Again, substitute Rohingya Muslim for Croat and check. The court did not find that all of these factors were present in Croatia, but they are all undeniably present in our case. Third, and this is the feature that most distinguishes Croatia from our case, the court found that Serbia's policy was to establish an ethnically homogeneous Serb state, following the forced displacement of Croats from the parts of Croatia and that Serbia hoped to annex, or at least control. The court found it determinative that this intention, quote, namely the forced displacement of the Croats, did not entail their physical destruction. It was not a question of systematically destroying that population, but of forcing it to leave the areas controlled by these armed forces. In other words, for the court, Croatia v. Serbia was a case of ethnic cleansing, but not genocide. To be sure, the one does not necessarily exclude the other. In the Bosnia case, the court explained that, quote, acts of ethnic cleansing may occur in parallel to acts prohibited by Article 2 of the Convention, and may be significant as indicative of a specific intent, dolus specialis, inspiring those acts. However, in the Croatia case, the court did not consider that Serbia's ethnic cleansing of Croats was indicative of an intent to destroy them as a group. Its findings were to the contrary. It concluded that, quote, Croatia has not established that the only reasonable inference that can be drawn from the pattern of conduct it relied on was the intent to destroy, in whole or in part, the Croat group. This further distinguishes the Croatia case from our case. Myanmar's pattern of conduct, in contrast to that of Serbia, does not permit the court to reasonably infer that its intent was to forcibly displace or ethnically cleanse the Rohingya Muslim group. Myanmar itself does not claim that this was its intent, or that such an intent can be reasonably inferred from its conduct. In fact, Myanmar has consistently denied this. To be sure, Myanmar's clearance operations caused massive forced displacement, in addition to killing, maiming, and raping of the Rohingyas. As the court explained in Croatia, the existence of genocidal intent in such circumstances depends on whether, quote, the forced displacement was carried out in circumstances calculated to result in the total or partial destruction of the group. The evidence in our case shows plainly that it was, as the fact-finding mission concluded. As Professor Sands told you, Myanmar argues that the clearance operations were intended neither to forcibly displace, ethnically cleanse, or destroy the Rohingyas as a group. Its only defense of this conduct is to claim that its actions were intended to combat terrorism, specifically to counter the activities of the Arakan Rohingya Salvation Army, referred to by the acronym ARSA throughout the pleadings. The clearance operations were exercised in counterterrorism against ARSA, says Myanmar, not efforts to destroy the Rohingya as a group. This is, frankly, a hopeless argument that is entirely unsupported by the evidence. But in the circumstances, it appears to be the best defense that Myanmar can gin up. And we will give it due attention over the course of our presentation this week, including with a speech on Wednesday devoted entirely to this issue. For now, as a sort of preview, I will simply make 3 points about it. First, it is fundamental and should not be debatable that actual counterterrorism is based on ensuring the safety and security of the affected population and gaining its loyalty and support. This cannot be reconciled with sending the armed forces to scores of villages, setting fire to homes with families still inside them, shooting at everyone who moves, rounding up men and boys for mass execution, hacking children and infants to death, raping, gang raping, and mutilating women and girls before killing them, forcing survivors to run for their lives, and then razing their villages to prevent them from returning. This is what the evidence shows Myanmar did. And it is a description of genocide, not counterterrorism. Second, this is not a case, as Myanmar has argued in its written pleadings, of applying Western standards to a less developed country in the global South. Yes, our expert witness, Professor Michael Newton of Vanderbilt Law School, U.S. military officer, but he has devoted both his military and academic careers to the law of war and particularly to matters of counterterrorism, including in non-Western and developing states. His expert testimony is that the fundamental principles of counterterrorism strategy and tactics are nearly universally accepted, including most significantly by Myanmar itself. This is reflected in the Tatmadaws' own rules of engagement, which Myanmar has very helpfully attached to its pleadings. There is no problem with these rules, according to Professor Newton. The problem is, as you will be shown by my colleagues, that Tatmadaw completely ignored them in carrying out its clearance operations against the Rohingya. Most prominently, as the UN fact-finding mission concluded, the killing of civilians is inherently brutal in any context. The perpetrators of the clearance operations in Rakhine State introduced an additional dimension to this. There was not the least effort to make any distinction between ARSA fighters and civilians, or to specifically target a military objective or identify and repel an immediate threat. Everyone was a target, and no one was spared. Mothers, infants, pregnant women, the old and infirmed, all fell victim to the ruthless campaign. The targeting of women and girls for rape, gang rape, and other forms of sexual violence, as well as the targeting of and impact on children in general, has been shocking. The brutality with which the underlying acts were carried out provides further support for a conclusion that they were committed with genocidal intent. My third point is that the clearance operations were by several orders of magnitude far out of proportion to what was needed to defend against ARSA. This is how the UN's independent investigative mission for Myanmar described ARSA's capacity in August 2017 when Myanmar launched its clearance operations. Based on photographs and videos released by the Myanmar military, publicly circulated footage, witness testimonies, and official statements, the mechanism found that by August 2017, ARSA likely possessed a modest arsenal of 40 to 70 firearms of mixed types and calibers. Most ARSA members primarily used bladed weapons, sticks, and a limited number of artisanal firearms. While IEDs appear to have been used in the 2016 and 2017 attacks, there is no conclusive evidence that firearms were employed. It is not surprising that Myanmar would attempt to transform ARSA, armed mainly with knives and sticks, into a major fighting force and national security threat. To be sure, we do not suggest that Myanmar should have ignored ARSA. As a sovereign state, it had the right to defend itself against such an outfit, even if it was as poorly equipped as the evidence shows. However, history teaches us that when genocide occurs, it is almost always under cover of armed conflict. In this regard, it would be wise to recall the words of Judge Cansado Trindade in the Croatia case partially quoted by Professor Sands. One cannot characterize a situation as one of armed conflict so as to discard genocide. The two do not exclude each other. In this connection, it has been pertinently warned that perpetrators of genocide will almost always allege that they were in an armed conflict and that their actions were taken pursuant to an ongoing military conflict. Yet, genocide may be a means for achieving military objectives, just as readily as military conflict may be a means for instigating a genocidal plan. Before concluding my presentation, I'd like to call attention to one more distinguishing feature from the present case and both the Bosnia and Croatia cases. In the prior cases, the court had the benefit of findings of fact by another international judicial body, namely the ICTY. To be sure, the court did not rely on those findings exclusively. In Bosnia, the court found helpful a report by the Secretary General on the fall of Srebrenica, describing it as having considerable authority because of the care taken in its preparation and the independence of those responsible for it. Likewise, in Croatia, the court found that it must give evidential weight to a report by the UN Special Rapporteur by reason both of the independent status of its author and of the fact that it was prepared at the request of organs of the United Nations for purposes of the exercise of their functions. Here, the centerpiece of our case has been from the very beginning the two voluminous reports consisting of more than 600 pages prepared by the UN fact-finding mission appointed by the Human Rights Council, which were published in 2018 and 2019. These too are notable for the care taken in their preparation and the independence of those involved. The evidence contained therein has been supplemented in the course of these proceedings by numerous equally independent and authoritative reports from the IIMM, other United Nations bodies, impartial non-governmental organizations, and various states, as well as 48 sworn statements from eyewitnesses, all consistent with the conclusions of the fact-finding mission, and all supportive of the Gambia submission that Myanmar acted with genocidal intent in carrying out its clearance operations against the Rohingya in 2016 and 2017. Mr. President, members of the court, I will speak again at the beginning of this afternoon session, delving further into the reliability of the sources of evidence on which the Gambia replies. And in the interest of time, I will simply conclude this presentation now by thanking you for your kind courtesy and patient attention, and asking that you call my good friend and esteemed colleague, Mr. Arslan Suleiman, to the podium.
I thank Mr. Leichtler. I now give the floor to Mr. Arslan Suleiman. You have the floor, sir.
Mr. President, members of the court, it is an honor to appear before you again and to represent the Gambia in this significant case. This case is about Myanmar's acts of genocide against the Rohingya group. As I will explain, there can be no doubt that the Rohingya are a protected group within the meaning of Article 2 of the Genocide Convention. Myanmar's refusal to recognize them as such, or to even use the term Rohingya, is entirely without effect or relevance. I begin my presentation by providing a view of the geography, demography, and history of a common culture. Memorial. The 9th century, when Muslims present-day Bangladesh. The Burmese army quashed that insurrection, whose fighters were referred to as Mujahideen. In July 1961, during the so-called Mujahid Insurgent Surrender Ceremony, Burma's Vice Chief of Staff of the Armed Forces, Brigadier General Aung Gyi, delivered a speech identifying the Rohingya as an ethnic group in Burma. His speech is at Annex 143 of the memorial. In relevant part, General Aung Gyi said the following, quote, "In central Burma, there are people who hold the view that people in this region are not Tai Yin Tha, or ethnic group native to the Union of Burma. These are false views. I want to openly and publicly tell you this. We consider the Rohingya people of Mayu district an ethnic minority integral to the Union of Burma. Let me be very precise about this. Those of you here ought to view yourselves as an ethnic minority of Burma. Only then will peace prevail in this region and in this country of ours." End quote. He went on to recognize the legitimate grievances of the Rohingya that had led to the insurgent movement in the first place, and declared that the persecution of the past was ending. Quote, "They said the Mujahideen rebellion broke out because of religious persecution. They said there was economic persecution. They said there was racial persecution. Yes, they are correct, as these rationales and explanations were true to a certain degree before. But that was the past. There is no more racial persecution, for we have emphatically and categorically recognized Rohingyas as an ethnic minority, making efforts for the progress and development of the Rohingya ethnic minority." End quote. Myanmar quotes from his speech in its rejoinder, using its own translation, to argue that General Aung Gyi referred to the Rohingya as the same ethnic group as existed across the border in present-day Bangladesh, and not as a distinct ethnic group in Myanmar. I will address the argument about the distinctiveness of the group shortly, but what is important is that Myanmar concedes that General Aung Gyi used the term Rohingya to refer to the Muslim majority population of present-day northern Rakhine State. Unfortunately, the commitment to recognition and inclusion and an end to persecution referred to in these speeches, the very same demands that the Rohingya have to this very day, did not hold true. Those who sought to exclude the Rohingya from the country soon regained power. In 1962, a military coup ousted the civilian government, And there began a long process of systematic persecution and discrimination against and exclusion of the Rohingya, extending and enlarging over the next several decades. This eventually culminated in the genocidal clearance operations of 2016 to 2018. Ms. Pasipanocha will go into further detail on the history of discrimination as one of the indicators of Myanmar's genocidal intent. I will now address why the Rohingya are plainly a protected group within the meaning of Article 2 of the Genocide Convention. Article 2 defines genocide as any of the acts listed therein that are, quote, committed with the intent to destroy in whole or in part a national, ethnical, racial, or religious group as such. As articulated in Bosnia v. Serbia, the court has defined a group for purposes of the Genocide Convention as, quote, a collection of people who have a particular group identity, end quote, that is defined by, quote, positive characteristics, national, ethnical, racial, or religious, end quote, which can be identified through a, quote, combined subjective-objective approach, end quote. The key objective factors include distinguishing well-established or immutable characteristics, such as language, religion, citizenship, or hereditary physical characteristics. The key subjective factors include self-identification, perceived characteristics, and socio-historic context. Myanmar argues that these ethnical, racial, or religious characteristics must be such that the group is, quote, distinct from the rest of the world's population. There is no basis in the court's jurisprudence for this extreme position, which seems more motivated by Myanmar's desire to deny the existence of the Rohingya group than an effort to reasonably address the court's standard for defining the group under the convention. There is also no basis in the court's jurisprudence to apply, as Myanmar seeks to do, a high standard of proof applicable to findings of genocide to the identification of the group at issue. As the court made clear in Bosnia, all that is necessary is that the positive and objective characteristics of the group are such that it would enable the court to, quote, have in mind the identity of the group against which genocide may be considered to have been committed, end quote. The identity of the Rohingya group is clear. First, the Rohingya are rightly considered as an ethnical group given their language, culture, self-identification, and their identification as such by Myanmar and the United Nations. Clear evidence indicates that the Rohingya group speaks a common language, namely the Rohingya language. As noted, British and German ethnographic documentation from 1799, 1811, and 1815 refer to the Rohingya language as being spoken by Rohingya in Burma. Furthermore, a 2018 report from the NGO Translators Without Borders found that among Rohingya refugees surveyed, all, quote, said that they speak Rohingya, with 99% of them saying it is their primary language at home, end quote. That it is the, quote, only spoken language that all Rohingya refugees understand and prefer, end quote. Myanmar has not challenged this evidence. Rather, Myanmar argues that the Gambia has not established that the Rohingya speak a language not shared by others in the Chittagong division in Bangladesh. That is not something that the Gambia is required to prove. The fact that the Rohingya share this specific language is a positive characteristic that helps to establish their identity as an ethnical group. As the Gambia noted in the memorial, the Rohingya language is related to the Chittagonian dialect of Bangla and considered by anthropologists and their own music, art, poetry, and foods. Myanmar again argues that these cultural characteristics may also be common to communities in Bangladesh, but that does not rebut the fact that these shared cultural characteristics allow for the identification of the Rohingya as an ethnical group in Myanmar. The subjective factor of self-identification is also highly relevant to the characterization of the Rohingya as an ethnical group. As noted, ethnographical reports from the 18th and 19th centuries document their historic self-identification as Rohingya. Myanmar's 2014 census because Myanmar did not allow them to self-identify as Rohingya in that census. Furthermore, Myanmar itself clearly recognized the Rohingya as an ethnic group in its early speeches of Prime Minister U Nu in 1954 and General Aung Gyi in 1961, clearly acknowledged and accepted the Rohingya identity as such. Moreover, Myanmar's long-standing discriminatory treatment of the Rohingya, which will be discussed in further detail by Ms. Pasipanochka, also confirms their And as noted in the Gambia's reply, the courts of several states, including Japan, France, and Australia, have all found persecution against the Rohingya based on their identity as such. All of these objective and subjective factors indicate that the Rohingya are widely recognized as an ethnical group within the meaning of Article 2 of the Genocide Convention. Second, the Rohingya are also a distinct group of Muslims for purposes of the Genocide Convention. It is not disputed that the Rohingya are predominantly Muslim. In fact, Myanmar consistently refers to the Rohingya by their religious the British colonial census data refers to Arakan Mohammedans, that is, Muslims of Arakan, the territory that is now Rakhine State, which is one way in which the term Rohingya itself could be defined. The Muslim faith identity of the Rohingya group is central to their otherization and dehumanization in Myanmar, key parts of the genocidal process to which they have been and are being subjected. Several discriminatory laws, like restrictions on marriage and on the number of children couples could have, were explicitly targeted against Muslims, as you will hear in the presentation later today. Group. Indeed, in its counter memorial, Myanmar states, "Not all Bengalis in northern Rakhine State are Muslim. A small minority are Hindu or Christian." Nonetheless, when the Gambia is referring to the Rohingya group, it is referring to that group based in part on its primary identity as a group of Muslims. Myanmar further argues that the Rohingya cannot be a separate religious group because they are not distinct religiously from the many Muslims in neighboring Bangladesh. But the existence of Muslims in Bangladesh is not relevant to defining a group in Myanmar for purposes of the convention. As we know from the court's decision in Bosnia, a geographical limitation combined with a religious identity can be used to define a group for purposes of the convention. For all these reasons, the Rohingya are a religious group within the meaning of Article 2 of the convention. Finally, the Rohingya are also a racial group under the convention. A racial group can be defined by objective characteristics like physical traits, as well as subjective factors like their socio-historic context and their perception by Myanmar authorities. Myanmar is a deeply race-based country. Citizenship is defined by belonging to 8 so-called national races. Myanmar's 135 officially recognized ethnic groups all fall within one of these 8 races. Despite the early recognition of the Rohingya as an ethnic group by Burma's political and military leaders, the Rohingya have since been excluded from these national races. Thus, Myanmar considers them to be a different race from these national races, which is effectively an admission that they are a distinct racial group. In describing the Rohingya, Myanmar officials have been documented as referring to their darker skin color and their being of, quote, Bengali stock. Myanmar's treatment of the Rohingya, which includes severe restrictions on movement and lack of access to healthcare, education, and livelihoods, is implemented by recognition of members of the group based on their physical appearance. The reality of this race-based treatment of the Rohingya, combined with their long history of persecution, constitutes a subjective factor allowing for their treatment as a racial group in Myanmar for purposes of the convention. Myanmar once again argues that these factors do not establish the Rohingya as a race separate from people of Bengali origin, but that is not what matters. So long as the objective and subjective characteristics allow the court to identify the group at issue in Myanmar, the Rohingya can be considered as a racial group for purposes of the convention. In conclusion, Mr. President, the relevant objective and subjective factors establish without the shadow of a doubt that the Rohingya of Myanmar are an ethnical, racial, and/or racial group for purposes of Article 2 of the Genocide Convention. Thank you, Mr. President, members of the court, for your kind attention. Mr. Reichler will give the Gambia's next presentation, but this concludes the Gambia's presentations for the morning session. Thank you.
I thank Mr. Suleiman. This concludes this morning's sitting. The oral proceeding will resume this afternoon at 3 p.m. The sitting is closed.